Good evening, everyone. It is 7 o'clock. We welcome you to the Tooele City Planning Commission meeting for Wednesday, December 14th, 2022. First thing on the agenda is the Pledge of Allegiance. If you would all stand up and recite the Pledge of Allegiance with me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Next on the agenda is our roll call. We recognize Council Members Manzione and Hansen. Happy birthday, Councilman Hansen. Mr. Bolser, Mr. Agard, and Mr. Hansen are also present. Commissioner Hammer.
Here.
Commissioner Proctor.
Here.
Commissioner Sloan.
Here.
Commissioner Hamilton.
Here.
Commissioner Jensen.
Here.
Commissioner Gochus.
Present.
I'm Chairman Robinson. I am also present. Commissioner Smith would like a minute to address the commission as part of roll call. So Paul, if you want to come forward, we'll hear from you now.
Thank you, I appreciate it. It's this much taller, isn't it? I want to take a moment. I'm sure most of you have heard, but I'm just going to say it now. I am resigning effective January 1st, so I won't be with you any longer. And I just wanted to take a moment and apologize to you guys. Apparently I was a bit overzealous in some of my comments and offended a number of you. And I certainly did not mean to do such a thing. And I just wanted to take a moment and apologize to any of you that I did offend. It was not intended to be so. I do stand by how I feel about certain things, but I probably could have said it a lot better. And I apologize for that. And I'd just like you all to know that. I respect you. I respect the job you guys do. You're an amazing group of people. You guys really represent the city the way it needs to be represented. I also want to say something about the staff. They're incredible. We have a staff that is way above our pay grade. They all work twice as hard as they should be for what they're paid. We're very fortunate to have each and every one of them. So anyway, that's pretty much what I wanted to say. I wanted to encourage you to continue doing what you do and listening to the public and being here for them each and every day. And don't forget, I'm feeling it right now. It's pretty intimidating standing here in front of you guys. So when they jump up here and they mess up their words a little bit, it's honest and fair. Let me tell you that. I can feel it right now. So anyway, I just want to thank all of you. I've really appreciated my time, the 2 years I put in here. And you guys are, like I said, a great group of people. So anyway, that's really all I had to say. I just wanted to thank each and every one of you for your time and doing what you do. Thank you.
Thank you, Paul.
Thanks, Paul.
Thank you, Paul.
Next on the agenda, public hearing and decision on a conditional use permit request by Tim Ryan representing Bout Time Pub and Grub for a private club bar on the property located at 615 North Main in the GC General Commercial Zoning District. Mr. Agard.
Paul's right. It is intimidating standing here in front of all of you.
Seriously?
But we manage. This application involves the old Sunlock Yan restaurant, and it involves the parcel highlighted in red on the aerial photograph. It extends all the way from Main Street back to 50 West Street, and is north of 600 North and just south of the existing Phil's Glass business. Property is currently zoned GC General Commercial, as are properties to the north, to the south, and to the east, and then some MR8 is located to the west. The applicant is requesting a conditional use permit in order to operate a sports bar slash pub at the inside the existing building, the existing Sunlock Yan building. They'll probably be doing some renovation work on the building according to what they need for their business, but all the details concerning the site and so forth are included in your staff report. We are recommending approval of the conditional use permit with the basic conditions listed in the report. This item does require a public hearing, and notices were sent to property owners within 200 feet. I have not received any comments up to this point from anybody that would have received those notices, or from anybody else for that matter. So with that, that's my presentation. If the Planning Commission has any questions, I'm happy to try and answer those for you.
Thank you, Mr. Agard. Any questions from the commission for staff? Hearing none, this does require a public hearing. We'll go ahead and open the public hearing. If there's anyone that wants to come forward and address this agenda item, now is the time to do so. Seeing no mad rush for the podium, we'll go ahead and close the public hearing and bring it back to the commission for a motion.
Mr. Chair, I motion we approve the conditional use permit by Tim Ryan representing Bout Time Pub and Grub, authorizing use of private club bar on property located at 615 North Main Street, application number P22-1328, based on the findings and subject to the conditions listed in the staff report dated December 5th, 2022.
Motion for approval by Commissioner Hamilton. Is there a second?
I'll second.
Seconded by Commissioner Jensen. Any discussion on the motion? Hearing none, we'll take it to a vote. Commissioner Hammer.
Aye.
Commissioner Proctor.
Aye.
Commissioner Sloan.
Aye.
Commissioner Hamilton.
Aye.
Commissioner Jensen.
Aye.
Commissioner Gochus.
Aye.
Chair also votes aye. That is approved 7-0. Next on the agenda, public hearing and recommendation on a zoning map amendment request by Wagstaff Investments to reassign the zoning for approximately 2 acres located at the northeast corner of Franks Drive and 1000 North from MR16 to RC Regional Commercial. Mr. Agard.
Thank you, Commissioners. You're familiar with this property, as at your last meeting, you entertained a land use map amendment, and you recommended approval to that. The City Council, in a subsequent meeting, approved that, and so the land use was changed on that property. This is the follow-up application. As mentioned, the property does sit northeast of the intersection of 600 West and 1000 North, and is highlighted in red. The property is currently zoned MR16 multifamily residential with MR16 located to the east, some neighborhood commercial located to the west, and some general commercial to the south. All immediately adjacent properties are currently vacant, undeveloped land. However, there is a gymnastics academy that is proposed for the property to the south, so that should be commencing construction soon. As I mentioned, the land use map was recently amended to RC, Regional Commercial. The RC Regional Commercial designation incorporates the Regional Commercial Zone as well as the Research and Development Zone. The applicant is requesting the property be rezoned to RC. This is how the zoning map would appear if that zoning map amendment is approved. The color might be different, but you get the general idea. This zoning map amendment is being requested in order to facilitate the construction of a Holiday Oil convenience store with gasoline services. This item is a public hearing. Notices were sent to property owners within 200 feet of the subject property, quite a few of them actually. I sent out 99 notices. We did receive some interesting comments today, but they were kind of garbled. You probably saw those come through on the PC comments, but they really didn't say anything. So I don't have any comments to report that were coherent. So that's where we are with this, and with that, I'll turn it back over to the Planning Commission for any questions you might have.
Thank you, Mr. Agard. Any questions, concerns, comments from the commission for staff? If not, this item also requires a public hearing. We will go ahead and open the public hearing. If there's anyone that wants to come forward to address this agenda item, now is the time. And seeing the mad rush from the last public hearing continue, we will close this public hearing and bring it back to the commission for a motion.
I'll make a motion.
Commissioner Proctor.
I move we forward a positive recommendation to the City Council for the Holiday Oil zoning map amendment request by Brent Neal, representing Wagstaff Investments LLC, reassigning 2 acres located at 1000 North Franks Drive to the RC Regional Commercial Zoning District application P22-1238 based on the findings and subject to the conditions listed in the staff report dated December 1st, 2022.
There's a motion for a positive recommendation from Commissioner Proctor. The chair will second that motion. Is there any discussion on the motion? Hearing none, we'll take it to a vote. Commissioner Hammer.
Aye.
Commissioner Proctor.
Aye.
Commissioner Sloan.
Aye.
Commissioner Hamilton.
Aye.
Commissioner Jensen.
Aye.
Commissioner Gochus.
Aye.
The chair also votes aye. That moves forward with a positive recommendation 7-0. Next on the agenda, a public hearing and recommendation on ordinance 2022-40, an ordinance of the City Council amending the City Code Section 7-1-5 and Chapter 7-15 about fair housing and residential facilities for persons with a disability. Mr. Baker.
Thank you. Good evening, Commission members. It's good to see you. The Federal Fair Housing Act is quite a complex act and area of law that few people understand, and I won't claim to be one of those few, but I understand portions of it. And for those portions I don't understand, I've relied upon attorneys that do. Chris, you may know the name Daniel McConkey, who's presented at the Realtor conferences and other conferences on accommodating the disabled in housing. Because under the Federal Fair Housing Act, which ties to the Americans with Disabilities Act, disabled people have every bit as much a right to enjoy housing as non-disabled people. Part of what that means is that if a disabled person or group of disabled persons or a disabled family want to live together in a single-family home in your neighborhood, they have every right to do so. They're a family. A family in our city code is defined as an individual or two or more persons related by blood or marriage, or up to 4 unrelated persons. So 4 college students could live together in a home and they're a legal family under the zoning code, not a family for other purposes. The challenge comes that for disabled housing, clinical studies have shown that for the group arrangement to be optimally beneficial to the disabled folks that are living together and supporting each other in their disabilities, requires about 8 people. And that to reach enough of a support group, but that it doesn't need to go necessarily to 12 or 16. So the question is, if disabled people have a right to live together just as much as non-disabled people, then how can we accommodate this larger group of people that exceeds our definition of family, but that can't live together in zoning districts that limit a family to 4. So the Federal Fair Housing Act and the Americans with Disabilities Act both require that if a regulation would discriminate against a disabled person or impede a disabled person to enjoy the same rights as a non-disabled person, I don't know if I'm using the right term there, but that the local government must grant a reasonable accommodation if we're asked to. If we're not asked to, we don't have to. We don't have to volunteer. But in this context, if a group of 8 disabled persons wanted to live in a home together, they could apply to the city for a reasonable accommodation and show that it's clinically helpful or even necessary for them to have that many people to provide the support that they need to enjoy their housing options. And we would have to go through an interactive process, dialogue, to talk about what kinds of accommodations would be reasonable. In the housing context, what would be reasonable is to allow up to 8 people. And we know that it is reasonable in most contexts because there are many families with 8 people and it doesn't undo the neighborhood. So in this case, it's just 8 unrelated people. And the research shows that it is reasonable to have up to that many people living together to provide the support they need. So after we receive an application for a reasonable accommodation, allowing 8 people to live together as a family, we then would have to have an administrative hearing officer or some land use authority hear that application, weigh the evidence, and make a decision on whether to grant the reasonable accommodation. And that has to be someone that knows this area of the law. So usually the hearing officer is an attorney who knows the Federal Fair Housing Act, and there aren't very many of them. So Sandy City, for example, every time a group of disabled persons wants more than 4, they have to apply for reasonable accommodation, and they have to have a hearing in front of the hearing officer. And then the hearing officer takes the evidence, does the research, and writes the report or the decision. And because of everything I've already told you several times, the decision is almost always going to be yes. But in the meantime, it costs $5,000 per hearing to have that expert lawyer come in and have the hearing, take the evidence, weigh the facts, and produce the decision. That's how they've chosen to go. So every time they get an application for reasonable accommodation, they have the hearing officer approves the accommodation and issues the decision, and the government writes a check to the hearing officer attorney. There's another city, South Ogden, that has adopted a different approach. They've basically said, since the hearing officer most likely is going to approve this accommodation of 8 people anyway, and since we know that the research supports a family of 8 disabled persons anyway, why are we going through this procedural motions, slowing things down, requiring the persons to apply and wait and have hearings and produce evidence? When we know it's going to get approved, why don't we just amend our code up to approve up front, up to 8 people? Let's put the reasonable accommodation right in the code. We don't have to go through all that delay and all that expense. It's going to be approved anyway, so let's just approve it. If they wanted 9 people, then they would have to go through the more lengthy, formal, expensive process of saying, actually, we need an accommodation of 9, and they would have to prove why. But South Ogden is saving a lot of staff time and out-of-pocket expense for hearing officers and lawyers by enacting in their code this new definition, this expanded definition of a family and the reasonable accommodation. So that's kind of a long explanation for a very short and simple amendment. In preparing this ordinance, instead of just looking at this one issue, we have read the entire chapter, as well as some other city ordinances, and brought into our chapter some concepts that we think would be helpful generally. But it's not new law, it's not new policy, it's just updating our ordinance to be better. So the only substantive change is adding the disabled group of 8 to the definition of family, and by thus doing, approving the reasonable accommodation for that size disabled family. Any questions?
Thank you, Mr. Baker. Any questions from the commission?
Mr. Chair, I have some questions.
Commissioner Goches.
Thank you. Mr. Baker, you indicated that this allows, the ordinance could allow up to 8 people. Does that include staff or caretakers who might be required to live on site?
That's a great question. because this is not a business, it's just a family living in a home, they would not be, there would be no staff living at the house. That would make it something else. That would make it a residential support facility or some other kind of facility that's actually a business operating with that group in the home. This is nothing more than a group of unrelated people living together as a family, just like you would have if they were a group of older people living together, or a group of college students living together, or some other arrangement of unrelated persons.
So that brings another question, and I did have that written down. Is this considered a business? But you've said no, you know.
It's not.
So because this is not a business and it's more of a single-family unit, do we need to consider an ordinance that would allow a business to be able to act under this premise? Is this is something else that is needed by the city?
It could be. It's a very different policy question of whether to allow a therapeutic type business to operate in a home. The staff is bringing to you, or maybe already brought, the residential treatment center to be approved in one of the mixed-use general zone. Jim, I'm sorry, have we had that discussion yet? We've finished that, I thought so, yeah. So you have approved a business type that provides residential treatment to, it could be disabled persons, could be elderly persons, or others. And that's a very, very different policy question than we're dealing with tonight. But you have dealt with it recently in one zoning district, and you could have discussions about allowing it in others.
Just one more question. Is there consideration for parking for that many people? I don't know that we govern parking in regular residences with people who have 8 drivers, but that seems like, you know, that there could be a possibility of a lot of cars. I don't know if that's a
It
consideration.
is a possibility. One thing I forgot to mention is that very often the group of people living together are disabled because they have had and continue to have an addiction to controlled substances, to drugs. This does not give any protection to using drugs, but one of the reasons the number of 8 is clinically important is that addicts of any kind need support from a larger group to help them not relapse into further abuse and to remain sober. Regarding parking, it would be possible to address parking and require additional parking, but if we define up to 8 disabled individuals as a family, then they would not have to provide any additional parking space relative to any other family that is not a disabled group. So there has to be parity between them. And if it could be that a hearing officer could say, well, with 8 people, you may have a larger impact than any other home. It's kind of subjective, and to whom do we compare that group? Many larger families have perhaps not 8 cars, but we see plenty of places with 4 and 5. So no, this does not require any additional parking. To do so would be possible, but would be more complicated than what we're proposing tonight.
Thank you.
Commissioner Sloan.
This is probably a stretch, but is there anything here that conflicts with our ADU ordinance? Specifically, I mean, parking is what brought it to mind. I know we've got requirements for parking with an ADU. I can foresee properties that had more than 6 or 8 people in them with an ADU.
Great question. So our ADU ordinance provides that for attached or detached accessory dwelling units, they have to provide one additional parking space per bedroom. So in a situation where you have, say, 4 bedrooms, they would have to provide 4 additional parking spaces each. And that's not unfair or discriminatory because it's not based on their status as disabled persons, but on pure numbers. An internal dwelling unit, if I remember correctly, the state legislature preempted us from requiring additional parking for a basement apartment. So conceivably, it's possible that you would have a family of 8 disabled persons living in a basement apartment. I don't know how likely it would be, but yeah, it's conceivable. And no, we could not, by state law, we could not require any additional parking for that scenario.
Thank you.
Any other questions? Okay, thank you, Mr. Baker. This item does require a public hearing. If there is someone who would like to come forward to address this agenda item, the public hearing is now open. If you want to come forward and go ahead and tell us your name, and then after you're through, if you'll go back to the back and write your name back with our notes taker so she gets that information.
Thank you. I'm a lifelong resident of Tooele. My name is Steve Valerio. I was just listening to how this amendment would affect. I'd like to have some comments on how it might affect the people of Tooele. Like he says, that's a really complicated and important subject. But I had some questions about some of his comments and how this would affect the community. Well, first, one thing he said was it cost them so he mentioned South Ogden as one, and he gives the examples of how things might work, but he don't say if that's in Tooele, locally, Utah, nationally. And so I think some of those things, since I grew up here and know, and by the way, I'm also a recovered alcoholic, but I've got many years sobriety. But he wants to says they're going to approve these, or most likely in the first place when they apply for this. But if that's the case, I think it would make a lot more sense to put the $5,000 right to the issue in the first place, rather than if they're going to presumably approve it anyway, because, on his comments on the disabled live together, he grouped them as up to 8 people, but he mentioned it like they're all disabled living together, and they're not, and that seems to be pretty confusing and it's not the normal to what you would call either a family or a family. And I think that just kind of makes, I don't know if he's trying to get a residential thing, but that dilutes the intent of how the federal hearing is. If you have to have an amendment to change this, you're going to have amendments to go along with other things to do along with regarding fair housing for disabled. And the other item I'd like to address is if he mentioned that there's the drug and alcohol in the criminal, I don't know if it's criminal, but a lot of times they got at least legal problems or financial problems. But the neighbors, he said he was talking about protection, but they think the neighborhood would have to be protected also. So I think people in the neighborhood should be have a notice. And I think there's also quite a few other issues, like the council brought up just a few, but I think that this needs to be taken up a lot more advisement. And like he said, he's not an expert on the legal matter, and I think there could be a lot more that could be gained by having more expert opinion on this issue.
Thank you, Mr. Valerio. Roger, I'm going to wait and see if there's any other comments. Is there anybody else that would like to come forward for this agenda item now? Seeing no one come forward, we'll go ahead and close the public hearing. And then, Mr. Baker, if you wouldn't mind, could you address Mr. Valerio's comments?
I couldn't possibly remember them all, but I'll address some that triggered some thoughts. First of all, both the Sandy and the South Ogden ordinances were drafted by the same federal fair housing expert attorney, Dan McDonald. So I have a high level of, and I've spoken with him about both ordinances. I have a high level of confidence that they're both competent approaches, lawful approaches. The idea behind enacting in the code the reasonable accommodation is to spare the local government budget from needing to spend that money in the first place, and rather than, so if Sandy has 10 hearings a year, that's 50,000 that they didn't have to spend. Another point is that I have intentionally avoided using the term group home. This would be a group home. It is a home for a group of disabled people. But I don't like using the word group home because it has decades of prejudice behind it and bigotry behind it, and it triggers in people's minds all kinds of fears and that have proven over time to be irrational in the context of 8 disabled persons living together to give each other support in their sobriety. So yes, it's a group home. But it's important to define then what group home means. And in this case, it's limited to the group home is a single-family dwelling occupied by a family of 8 disabled persons. Does that trigger any more thoughts or questions from the commission?
Thank you, Mr. Baker. Bring this back to the commission for any further comments, questions, or should anyone like to make a motion on a recommendation on this agenda item? Commissioner
Chairman,
Loches.
I have a question, and I appreciated Mr. Valerio's comment and that he indicated that neighborhoods require protection. Would this require that we give notice to residents that live in this area, that a group home could be in their neighborhood, or?
Thank you. The short answer is no, but I'd like to explain why. Because the intent of the law is to make sure that disabled persons are not subjected to processes and expenses and humiliations that non-disabled people are not subject to. And so we would not give the neighborhood notice that disabled folks are moving in any more than we would give the neighborhood notice that you are moving in. And parity is the objective.
But one more comment to follow up with that. If this were a business, then we would have different stipulations, that there would be notice.
It would depend on whether the city council had established this as a permitted use or a conditional use. If the city council were to say that a residential treatment center in an R17 neighborhood will be a conditional use, then yes, the neighbors would be notified of the conditional use process and have a public hearing. But I'll just give you benefit of my experience and my training that it would be a legally and socially destructive thing to do and dangerous to subject disabled people to that kind of process. You've all seen it happen in public hearings where people come to complain about those people. And we had one hearing where it was about apartments, and every apartment dweller was a drug addict. And I boiled over because I lived in an apartment and corrected the person on that point. But so I didn't mean to get personal there, but that's the best I can answer your question.
Thank you.
Mr. Valerio, we've closed the public hearing.
I'd like to readdress what Bill said about my comments.
Well, afterwards, it would probably be best to talk to him. And this item is actually a recommendation, so it's going to come back before the city council again, too. So you'll have another chance to speak there as well. Anyone want to entertain a motion on this item on the commission?
I don't have my verbiage in front of me, but I've moved that we forward a positive recommendation to City Council on this ordinance.
There's a motion for a positive recommendation from Commissioner Sloan. Is there a second?
I'll second it.
I heard Tyson first, so seconded by Commissioner Hamilton. Any discussion on the motion? Hearing none, we'll take this to a vote. Commissioner Hammer?
Aye.
Commissioner Proctor?
Aye.
Commissioner Sloan?
Aye.
Commissioner Hamilton?
Aye.
Commissioner Jensen?
Aye.
Commissioner Goches?
Aye.
Chair also votes aye. That moves forward to the City Council with a 7-0 positive recommendation. Next on the agenda, recommendation on a subdivision plat amendment request by Cook Builders to amend lots 2, 3, and 4 of the Orstrut subdivision amended plat for property located at approximately 600 East, 2400 North. Mr. Agard.
Thank you, Commissioners. This subdivision plat amendment pertains to the property highlighted in red on the aerial photograph. It's immediately north of 2400 North, east of 400 East, and Lydiard's Home Furnishing is currently vacant property. The the zoning of the property is general commercial. As you can see, there's some light industrial, research and development, and general commercial zoning around the subject property. The current subdivision appears in this configuration. You'll notice that the lots that are being affected by this plat amendment are highlighted in green, or shaded in green. The applicant, which is actually Ford Performance Racing Center, you're probably familiar with those, you approved their site plan a couple meetings back. They wish to amend the plat and combine those 3 lots into one lot, resulting in a 4.5 acre parcel. They are doing this in order to permit the construction of their relatively large building without crossing over property lines, which is illegal. So this will accommodate that and enable them to construct their building without any property line issues. When properties get bigger, there really isn't much of a zoning issue, so it's a pretty simple matter. And we're recommending approval with the conditions listed in your report. I think they're very basic conditions. If you have any questions, I'd be happy to answer those for you.
Thank you, Mr. Agard. This one does not require a public hearing. Are there any questions, concerns, comments for staff on this item? If not, I will entertain a motion on a recommendation on this item.
Mr. Chair, I move we forward a positive recommendation to the City Council for Orstrut's subdivision plat amendment to request by Austin Anderson representing Cook Builders, thus vacating and amending lots 2, 3, and 4 of the existing Orstrut subdivision amended plat, application number P22-825, based on the findings and subject to conditions of the staff report dated on December 1st, 2022.
Motion for a positive recommendation by Commissioner Hamilton. Is there a second?
I'll second.
Seconded by Commissioner Goches. Any discussion on that motion? Hearing none, we'll take it to a vote. Commissioner Hammer?
Aye.
Commissioner Proctor?
Aye.
Commissioner Sloan?
Aye.
Commissioner Hamilton?
Aye.
Commissioner Jensen?
Aye.
Commissioner Goches?
Aye.
The chair also votes aye. That moves forward with a 7-0 positive recommendation. Next on the agenda, decision on a site plan design review request by D.R. Horton for the Western Acres Phase 2A townhome development located at approximately 1800 North, 300 East. Mr. Agard.
Thank you, Commissioners. So this application, this site plan design review request, pertains to the uniquely shaped parcel highlighted in red on the aerial photograph. It is located at approximately 1800 North, 300 East, and is Phase 2 of the Western Acres development, which is proposed to be a very large development. The zoning of the property is MR16 PUD, as are properties to the east and to the south. And then we have some light industrial to the west, as well as some general commercial. The general commercial is not actually utilized as commercial. That is the Overpass Point Mobile Home Park. That is a legally non-conforming use in the general commercial zone, but is in fact residential. This is the proposed site plan for Phase 2A of this development. It picks up pretty much where Phase 1 left off. There are no new road connections to public streets being proposed with this. This phase will pick up pretty much where Phase 1 stops. What they're proposing in this phase, the construction of 3 types of townhomes. There will be a rear-loaded townhome that fronts onto Pine Canyon Road. There will be front-loaded townhomes that front onto the interior streets. And then there are some townhomes that you can note do not have garages. Those are the ones that are adjacent to the parking lots. The site plan has been reviewed extensively by staff, and we are confident that the buildings and so forth meet the requirements of both the Tooele City Multifamily Residential Design Guidelines as well as the overall PUD qualifications. This is the landscape plan. This was included in your packet as well. Just kind of shows what their intentions are for boundary landscaping, landscaping adjacent to the buildings and so forth. Greater details of the landscaping plan are included in your report as well. They did provide an amenity plan. Phase 2A will include 6 new amenities. That was included in your packet as well for your information. And then the buildings they're proposing, this is the rear-loaded townhouse. And then the front-loaded townhouse. And then the townhome that is proposed without the garages. We anticipate that the color scheme would be the same as the elevations that you saw previously. Now, in reviewing these site plans, staff, speaking for myself, particularly because I review these, I try to be very efficient. Occasionally, I miss something. And these site plan design reviews are very effective because a lot of times I catch things that I miss. In this case, I missed two minor items, and I was hoping the Planning Commission could address these. The first one is the fencing. The staff report goes over the fencing. The only place where fencing is required is where the project is adjacent to Overpass Point. And in that case, that is the area with the north arrow. The ordinance requires fencing when the project is adjacent to either a different land use or a different zoning. In this case, that's general commercial zoning next to MR 16. So in that case, the ordinance requires that solid view obscuring fence with masonry piers is installed where a fence, a solid fence is not present. I do not believe there's a solid fence next to Overpass Point. So one of the conditions in the report is that the applicant needs to address the fencing. And we would like to see that on the plans. The other issue that I discovered as I was writing the staff report is on the southwest corner, there are 10 of those townhomes that do not have garages. You'll note that the other ones, they designate covered parking. Now, the ordinance requires 1 parking stall to be covered, either through a canopy or through a garage or other covered situation. So they've delineated the covered parking on the townhomes to the north, but on the ones on the southeast corner, they don't have that parking delineated, the covered parking. And so if the Planning Commission could just add a condition in there that they delineate covered parking on all of those non-garage townhomes, I would be very appreciative. Otherwise, we have reviewed this application very extensively. The applicant will attest to that. And we are confident that they are meeting or exceeding the minimum design requirements of both our design guidelines and the PUD. So if you have any questions, I'd be happy to try and answer those for you.
And they know about the fencing and the delineating the covered parking already?
I did make them aware of that, yes.
Okay. Thank you, Mr. Agard. Any questions, concerns, comments on this item from the commission? If not, I will entertain a motion on this decision item.
Mr. Chair, I move we approve the site plan design review requested by Mike DiCarlo, representing D.R. Horton, to approve the site plan for Phase 2A of the Western Acres development, application number P22-439, based on the findings subject to the conditions listed in the staff report dated December 7th, 2022, with the addition of 2 additional conditions. 1, solid view with masonry pier fencing in the areas that butt up against Overpass Point, and 2, that they cover the uncovered parking on the non-garage townhomes.
Motion for approval by Commissioner Sloan. Is there a second?
I'll second.
Seconded by Commissioner Hammer. Any discussion on the motion? Hearing none, we'll take this to a vote. Commissioner Hammer.
Aye.
Commissioner Proctor.
Aye.
Commissioner Sloan.
Aye.
Commissioner Hamilton.
Aye.
Commissioner Jensen.
Aye.
Commissioner Goches.
Aye.
The chair also votes aye. That is approved, 7-0.
Sure don't want to be their surveyor.
Next on the agenda, a recommendation on a preliminary subdivision plan request by D.R. Horton for the Western Acres Phase 2A subdivision located approximately 1800 North, 300 East. Mr. Agard.
Thank you, Commissioners. This is a follow-up application to the one you just approved. I think you understand where it is and what the zoning is, so I'll skip right through those. The preliminary subdivision plan is a little different from the site plan in that this application establishes lot lines. And what the preliminary plan does is it creates the individual lots for individual ownership. Those lots are essentially the footprint of the townhome. Those would be able to be sold, rented, whatever the owners want to do with those. There is no lot size minimum requirement in the MR16 zone. That is done to facilitate individual ownership of townhomes. The preliminary plan also creates limited common areas. They are the hatched areas adjacent to the footprint of the building. Those usually incorporate the driveways and the individual patio spaces of each unit. They are owned by the development, but they are limited in how they can be used to the adjacent lot owner. And then the common areas, the stormwater detention basins, the private streets, those are delineated in white as just common area owned and maintained by the development HOA. So that's the nature of this application. It's just all about creating lot lines and boundaries. They do conform exactly with the site plan that you just approved. And we are recommending approval of the preliminary plan with the basic conditions listed in your staff report. Happy to answer any questions for you.
Thank you, Mr. Agard. Any questions, concerns, comments from the commission on this item? Hearing none, I will entertain a motion on a recommendation for this preliminary subdivision plan request.
I'll make a motion.
Mr. Proctor.
I move we forward a positive recommendation to the City Council for the Western Acre Phase 2A preliminary subdivision plan request by Mike DiCarlo representing D.R. Horton application P22-601 based on the findings and subject to the conditions listed in the staff report dated December 8th, 2022.
Motion for a positive recommendation by Commissioner Proctor. The chair will second that. Any discussion on the motion? Hearing none, we'll take this to a vote. Commissioner Hammer.
Aye.
Commissioner Proctor.
Aye.
Commissioner Sloan.
Aye.
Commissioner Hamilton.
Aye.
Commissioner Jensen.
Aye.
Commissioner Goches.
Aye.
The chair also votes aye. That moves forward with a positive recommendation, 7-0. Next, a decision on a site plan design review request by Frank's Apartments for the Slatewood Apartments located at approximately, not approximately, this one's at 1201 North Franks Drive in the MR16 zoning district. Mr. Agard.
Thank you, Commissioners. So this application pertains to the wedged-shaped parcel highlighted in red on the aerial photograph. It rests immediately east of Franks Drive and north of the future Barra Boulevard, which hopefully will be soon constructed with this development. Property is zoned MR16, as are properties to the south. We have some R17 to the north and to the east, and then some more MR16 located to the west. This proposed site plan design review proposes the construction of 3 apartment buildings consisting of 72 units. As you can see on the site plan, the buildings are located closer to Franks Drive with parking areas located to the east and to the center of the development. They are also proposing the construction of a clubhouse located at the southeast corner. This development will also facilitate the final construction for Franks Drive along the frontage and some of those improvements to Barra Boulevard to the south. This is the landscape plan that was provided by the applicant. We reviewed the plan according to the landscape standards and are recommending approval of the landscape plan. And then these are the building elevations. This is the 12-unit building, the front, and the 12-unit building of the rear. Those are identical elevations. And then the side elevation of the 12-unit building. And then this is the 30-unit building, the front elevation. And then the rear elevation, there's some minor differences there in the canopies over the large columned areas. And then the side elevation. Staff has extensively reviewed this application for conformance with the multifamily residential design guidelines, and we're confident that it does meet those. There was one area of ambiguity in regards to their building elevations. It involves the amount of brick or stone that is on the exterior of the building. These elevations were actually designed according to the previous ordinance, where it was 75% of the front and so forth. The ordinance is now 60% of the front, 50% of the overall building, and then 40% of side facades that face the street. Their elevations don't confirm that they actually meet that requirement. I believe they do, based upon what my limited ability to check that, but I just need the applicant to provide revised building elevations that provide the numbers that indicate that. There should be a condition in your staff report that addresses that. So otherwise, we're recommending approval, and have any questions, happy to try and answer them for you.
Thank you, Mr. Agard. Any questions, concerns, comments on this agenda item?
I have a question.
Commissioner Hammer.
I have two questions, really. About parking. So it requires the covered stalls. How many did it see? Was it 18? I'm trying to find where it was. 18. Well, there are some that, 72 of the parking stalls will be covered by a canopy. Do they charge extra for that canopy covering? And if so, would that create some on-street parking problems?
Well, I don't know if they're going to charge for that or not. I don't know. I don't believe there's anything in our ordinance that would prohibit that. I don't know, Jim, are you aware of anything that would prohibit that?
There actually is a statement in our ordinance that they're not allowed to charge for parking. How they get around doing that is up to them, but that is, even though we do have that in our ordinance, it is a difficult provision to enforce. But there is a statement in there that they are not allowed to charge for parking.
So parking.
Charge for required parking.
Right. So if parking became a problem, then would somebody from the city visit with them to make sure that ordinance was being followed? Or how does that work?
Yeah, it would need to be complaint driven. We wouldn't actively go out and monitor their parking and charging requirements. That's a private business entity. But if there was an issue where we were made aware of a situation like that where parking was made difficult because of some added charge or whatnot, we would make an effort to visit with them on that point. Ultimately, it would be a difficult enforcement, as I mentioned, but we would reach out to them, yes.
Okay, thank you. I have another question.
Shoot.
Who's going to maintain the landscape maintenance, snow removal on Frank's Drive there on the?
They would be responsible to maintain all of their frontage landscaping. So the development would be responsible for that.
Okay.
I do have one comment. I really
Commissioner
like how
Hamilton.
they used the parking as a buffer for the houses right there. I've seen too many developments where you got a 3-story apartment building right in someone's backyard, so I really like the parking used as a buffer and the clubhouse as well, so I think that fits in well.
Any other comments, concerns, questions from the commission?
Mr. Chair, I have just one comment to follow up with what Ms. Hammer discussed. Frank's Drive is a public road, so they wouldn't be responsible for snow removal. Is that correct?
Yeah, the city would be responsible for snow
City's
removal on the street.
Thank you.
If there's nothing further, I will entertain a motion on this agenda item for approval or disapproval.
Mr. Chair, I move we approve the site plan design review request by Mark Horn representing Frank's Apartments LLC for the Slatewood Apartments, application number P22-70, based on the findings subject to the conditions listed in the staff report dated December 2, 2022.
Motion for approval by Commissioner Sloan. Is there a second?
I'll second.
Seconded by Commissioner Hamilton. Any discussion on that motion? Seeing none, we'll take it to a vote. Commissioner Hammer.
Aye.
Commissioner Proctor.
Aye.
Commissioner Sloan.
Aye.
Commissioner Hamilton.
Aye.
Commissioner Jensen.
Aye.
Commissioner Goches.
Aye.
Chair also votes aye. That is approved, 7-0. Next on the agenda, the setting of dates, times, and places for our regular meetings for the 2023 calendar year. Mr. Bolser.
Thank you. Good evening, Commissioners. I don't know what they're stressing about. This is easy up here. I have to say, recently I had the opportunity to speak before a group of people I'm familiar with, and I found that to be very stressful. And so it's definitely not easy. After 22 years of doing this, it's just become kind of commonplace for me, but it still isn't easy. This item is a yearly requirement for you all to set your formal regular meeting schedule for the following calendar year, this being the final meeting of the Planning Commission in December, at least your regularly scheduled meetings. This is the appropriate time to do that. In your packet, you received a memo that looks very, very similar to the ones you've seen in years past, identifying the meeting schedule for next year. This meeting schedule follows the typical pattern that has been observed for Tooele City's Planning Commission for many years, being the second and fourth Wednesdays of each month at 7 o'clock in the Tooele City Council chambers. Those dates for 2023 will be the 11th and 25th of January, the 8th and 22nd of February, the 8th and 22nd of March, the 12th and 26th of April, the 10th and 24th of May, the 14th and 28th of June, the 12th and 26th of July, the 9th and 23rd of August, the 13th and 27th of October, the 11th and 25th, of September, the 11th and 25th of October. And then for the months of November and December, again, as typical, we are only scheduling the first meeting of those 2 months to avoid conflicts with observed holidays. So the meetings for those 2 months would be the 8th of November and the 13th of December. Staff's hasn't identified any other holidays or significant dates observed by the city that fall in reasonable conflict with any of these dates, and so according to your typical pattern and schedule, those are the dates proposed for your regular business meetings for calendar year 2023.
Thank you, Mr. Bolser. Any comments, worries about that calendar as presented? If not, do we just have to have a motion to approve that as noted?
Correct.
Okay. Does someone want to make a motion to approve that? Don't all jump at once.
I move to approve those dates, times, and places for our meetings for next calendar year.
Motion to approve by Commissioner Hammer. The chair will second that. Any discussion? Hearing none, we'll take it to a vote. Commissioner Hammer.
Aye.
Commissioner Proctor.
Aye.
Commissioner Sloan.
Aye.
Commissioner Hamilton.
Aye.
Commissioner Jensen.
Aye.
Commissioner Goches.
Aye.
Chair also votes aye. Those dates are approved 7-0. Next, the nomination and election of a Planning Commission chair and vice chair for all of those meetings that we just set up.
This is one of my favorite ones of the entire year because we get to see who's friends and who's not. As the commission is aware, in your bylaws, there are procedures for a yearly election of a chairperson and vice chairperson. According to the bylaws, the chairperson can only be selected for 2 years in a row and then has to take a break. There is not a limitation on the vice chairperson. So having served just one consecutive year, Chairman Robinson is available for re-election and appointment to the chairperson if you all so desire. And in fact, I believe Commissioner Goches is still technically an alternate, so the remaining 6 of you would be eligible for selection as either chair or vice chair. So typically I do these so that it takes the chairperson out of these. So I would accept any nominations for chairperson for 2023.
I'm going to nominate Commissioner Hamilton.
No hesitation.
None.
You've been thinking about this for a while, haven't you?
That's what you get when you take a break. 2 years and
You
then a
had your
break, you're
requisite
back in
year
the
off.
play. You're back in the pool. Any other nominations for chairperson?
Seeing none, I move that we accept that by acclamation.
Commissioner Hamilton, are you amenable to serving as chairperson once again?
Yes, sir.
Okay. So with that, we do not need a vote. You are the chairperson for 2023. Congratulations. Vice chairperson, same process. Commissioner Sloan serving as our current vice chairperson. Again, there's no limitations on consecutive years, so I would be happy to entertain a nomination for vice chairperson for 2023.
I'll nominate Chris Loan.
Are there any other nominations?
Nope.
So hearing none, Commissioner Sloan, are you amenable to serving? With that acclamation, we do not need a vote. So congratulations, Commissioner Sloan. You are once again our vice chairperson for 2023.
Got 6 months of vacation scheduled.
Thank you, commissioners. Congratulations, Commissioner Hamilton and Commissioner Sloan.
Okay, next, the discussion regarding assignments to the pre-development meetings for the 2023 calendar year.
As the commission is aware, on Wednesday afternoons, we hold a pre-development meeting conducted by staff. This is for applications that are preparing to submit formal applications. It's an optional step in the process. They do not have to do this, but many applicants have found it helpful in identifying potential roadblocks or hurdles that they have to address during the formal review process of an application. We have found great success in having a member of the council, it's typically Councilmember Manzione who's there, as well as a member of the commission attending those meetings, not only for the relationship back to their respective bodies for information on those applications, but also for input to the applicants. And the applicants have expressed on a number of occasions their appreciation for the elected and appointed bodies' attendance at those meetings. There's a variety of staff that attends from all different departments in the city so that we have as complete a picture for our applicants as we possibly can, as well as the mayor often attends as well. So there's definitely an elected and appointed presence there on many occasions. So what I've put together in your packet here is just a draft calendar of potential meeting dates. We typically don't meet every week. We only meet as applicants come forward. So there'll be stretches where we're meeting every week, and there'll be stretches where we don't meet for several weeks. It's just a matter of when applicants come forward with a request. So the intent is simply to see if there are blocks of time that any of you would like to volunteer, whether that's 1 week at a time, a month at a time, the entire year at a time, whichever you choose to do, just so that we can have an understanding when applications come in, who is up for that representation from the Planning Commission, and we can not hold up an applicant while we're trying to figure out who's going to attend. So I'd be happy to let you all determine for yourselves if and who and when any of you would like to attend throughout the year. You'll note that there are several that we've identified already for not holding a meeting. As of right now, the remaining blank dates would all be eligible for having a meeting.
Historically, we've kind of done this by month, and it seemed to work pretty well. So I would propose that we stick with that, and we get at least through June scheduled tonight. So we've got a good head start on things. That being
I
said,
have a question.
shoot.
Is pre-development still held at 3:30?
It is 3:30 in the
time?
afternoon upstairs in the large conference room. Thank you. I forgot to mention that.
Does anyone have any months that they want to claim right off the bat?
Put me down for April.
I would be available January or February.
Okay, so we'll give
Why don't I tell you
West
what,
January.
let me take January and give him February, because
Okay.
while legislative session's on, I can't do anything for February or March.
All right, so we've got Chris in January, Wes in February. I'll take March. Tyson's got April. Takers for May or June?
I can volunteer. I'm not sure if I'm eligible as an alternate.
We'll take
You are. You absolutely are.
Yeah,
I'll take me.
I'll
Okay.
take June.
Chris has got June. And then after that, it's Tyson's problem.
Matt, for the rest of the 6 months.
Yeah, we can certainly bring this back, probably May, June timeline.
Let's do that.
Look
Is
at
that
it
okay?
again for the
Is that
second
all right
half
with
of the year.
everybody? Okay.
Thank you very much, Commissioners.
Next on the agenda is city council reports. Councilmember Manzione.
I've never gotten the impression she was intimidated standing up there. Have you?
Maybe I am. I don't know.
You don't sell it that way.
Oh, thanks. I always feel really short, though.
I wasn't going there.
Okay, a couple of things from our business meeting that we had last week. One is we approved a franchise agreement with an All West to install fiber to everywhere in Twila that doesn't have it already. So that's everywhere in Twila, so that's good.
That's done like by Tuesday, right?
It's done by Tuesday, so if you have problems before that, sorry. No, they plan to be done by the end of 2023, so pretty quick.
Very cool. That's fast.
And then we also are approved an agreement to do a water reclamation facility master plan update. We haven't done that for a while, so the last one was 2008, I think. So that will be great, as we look at impact fees and things like that, that will help drive that. We also approved an increase in the pool, some of the fees at the pool, and that hasn't been changed since 2015. So it was good time. It took us several months talking about that. And then the last thing I wanted to bring up is that we did visit the annexation petition. Somebody asked me about that a couple months ago, and it did not pass. It needed a 4 out of 5, and it got 3. So those were the only things that I thought you might be interested in.
Okay.
Any questions?
Thanks, Marisa.
Okay.
Next, the review and approval of the minutes for the meeting held on November 9, 2022. Any corrections, edits, fixes to those minutes?
I don't have any corrections or fixes, but I thought, since it's the last meeting of the year, well done on the minutes.
Yeah, she does a great
There's
job.
very few corrections.
Okay,
That I'll move to approve the minutes. There are no corrections or additions for November 9th, the minutes for November 9th.
motion to approve by Commissioner Hammer. Is there a second?
Second.
Seconded by Commissioner Jensen. Hearing no discussion, we'll take this to a vote. Commissioner Hammer?
Aye.
Commissioner Proctor? Commissioner Sloan?
Aye.
Commissioner Hamilton? Aye. Commissioner Jensen? Aye. Commissioner Goches?
Aye.
Chair votes aye as well. Those are approved 7-0. Does someone want to make a motion to adjourn?
Before you do that, if I can, just very briefly, as I always do in your last meeting of the year, I want to thank all of you again for a year of service. Just a quick stat, as the commission is aware, there's a minimum, by state law now, there is a minimum number of hours of training for each commissioner each year. That is a minimum of 4 hours of training for each commissioner. I'm happy to report that all of our commissioners met that requirement. Once again, we've yet to have one that fell short. And in fact, we had a majority of the commission that had more than 10 hours this year. So that is a great commendation to all of you. Very well done. But more than anything is the last meeting of the year. Thank you all for your service, and hope you have a very happy and safe holidays, and we will see you at your first meeting in 2023 on January 11th.
Thanks, Jim.
Thanks, Jim.
Andrew.
Now, move to adjourn.
Motion.
So accepted. We are adjourned.